All right, good morning. We're on the record in the 89th District Court for the County of Sheboygan. We're here in the matter of contempt of Beth Bridgman. It was committed and filed under the case of People v. Seth Flores, filed 23-0868SD. Counsel, you want to state your appearance for the record, please?
Melissa Goodrich, Sheboygan County Prosecutor.
All right, Ms. Bridgman is not present in the courtroom. Have we confirmed she's not out in the hallway? Okay, she's not out in the hallway. Ms. Bridgman was, the court issued a order to show cause why she should not be held in contempt for the unauthorized practice of law and also preventing defendant Flores from meeting with his attorney before his arraignment. I do see in the file a proof of service that she has been served with that, and in fact also in the file where Ms. Bridgman has returned the show cause cut into pieces with red writing on it stating your offer to contract is not accepted. So she apparently this was received today by the court. So she's been to the courthouse this morning to deliver this. Is not present for her show cause prior to the issuance of the bench warrant. I guess I'd give her a 15-minute window to appear. It is 11:03 right now. We'll go off the record and recess until 11:15 and reconvene. If she does appear sooner, just let me know and we can reconvene at that time. We'll be in recess till 11:15. All right, we're back on the record and recalling the case of in re contempt of Beth Bridgman, file 23-0868SD. It's now 11:16. Ms. Bridgman is still not present in the courtroom. Is she present in the hallway?
Not present.
Okay, she's not present. This appears to be a willful non-appearance due to the fact that she's returned the show cause affidavit and the order with it cut into pieces with the red lettering. Your offer to contract is not accepted. Of course, it's not an offer, it's an order of the court to show cause. She has now willfully not appeared. Ms. Goodrich, do the people have a request?
Your Honor, at this time, since we're here on a show cause, she's been properly served and also given an additional 15 minutes to appear. We would ask for a bench warrant to be issued.
Request as to bond?
No bond.
I think given the willfulness of the behavior, we'll set bond at arraignment. So I'll issue a warrant for Ms. Bridgman's arrest for her contempt for non-appearance today with no bond to be pre-posted. All right.
Thank you.
Such an interesting out there.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of in re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as a arraignment attorney on behalf of Beth Bridgman.
Right, good morning,
Also, I will represent myself.
Yes,
Okay.
we'll get to that.
I would like to say I'm here on special appearance.
Okay.
No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So
but
I am
now's
waiving,
not the time.
I am not waiving
Now's
any of my
ma'am,
rights.
Ma'am. Okay, thank you.
Ms. Bridgman, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull a chair up, so thank you.
Well, if you want to sit there, I have no problem. All right.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it says your offer to contract is not accepted. And then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So,
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the two contempt citations pending against you. You have the right to have a hearing on both of those allegations where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
what is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know, well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the contempt citations. Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call in to the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause, and she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Ma'am,
Okay, now,
did you just understand what the judge asked you regarding those two charges?
Did you just understand that I think there's a bigger overriding issue?
But
Thank you.
Hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Ms. Bridges.
I guess I just like to, state that
well, I think we need to
she's
back it up.
pleading not guilty to both of those, and that she would
Okay.
like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No,
Your
but
Honor, I
all
just
of my
want to-
rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She
can
was
present that.
working,
Okay, you're gonna get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridges.
Okay,
I mean, it's a pretty serious thing to have to spend the night in jail. to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right, if she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she was
purpose is
investigating.
to-
Okay.
Today's purpose is to advise you of the 2 contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask what statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have a cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay? It does not say.
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
Why have they changed,
I'm
Judge
not
Buckley?
answering that question.
Can the prosecutor?
No,
Why?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes, I
Okay.
do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse,
So are those,
then I'm going to appoint
I'm not
an attorney for
refusing.
you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know, I listened to that with Trevor's case.
All right, so I'm asking you, and you saw what
How
happened,
can I
Ms. Bridgman? So I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand that.
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gothier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's
common law
not about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty.
Correct.
That's correct. Okay. All right, so we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will. I'm not
Okay,
gonna argue
and
with you about what they
And
are.
the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one now,
What is
Okay.
what one you have?
and this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items check marked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do,
All right,
okay?
all right.
Now,
I'm gonna find
what I'm, please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one,
Would Your Honor like to see what she has
But-
here?
I just, so if you
okay,
don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show.
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Your Honor, what is the date of the first show cause?
December 20th.
No, the December.
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then.
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do. And
Okay,
that is a hearing date. Today, we're going to schedule a hearing date and you can present that evidence at that time.
and how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury.
for a
in
contempt charge?
So I
Oh,
can
so
schedule
this is a perfect, nice little tidy package for everything. I see. Okay,
So I can schedule this for a contempt hearing on Thursday, January 11th at 2 p.m.
I think that would be way too soon for me. Thank you.
Why is that?
I need to get to some of the documentation and follow up with that, state trooper, as well as perhaps a few other people, because I'm guessing, am I supposed to just talk to the prosecutor without the other witnesses that I had in my presence at the same time?
I could schedule this for the afternoon of Thursday, January 25th, then that gives you 3 weeks.
Thank you.
So we'll schedule this for a contempt hearing on both allegations of contempt on Thursday, January 25th at 2 p.m. And do I understand correctly, you do not wish me to appoint an attorney that you want to represent yourself?
And then who makes the decision? You make the total decision then?
Well, no, first you make the decision whether you want to represent yourself. As long
No.
as I'm convinced that you're doing so of your own free
Okay.
choice, that you understand what's going on and that you're not going to be unduly disruptive, then you'll represent yourself.
So what am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath,
Okay.
yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to subpoena somebody, what you would do is you go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review. And if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena. And it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Okay, well, that's all going to be sorted out at the hearing. Okay, we don't have to sort all that out today.
Well, that's a lot of overnight in being arrested downtown and everything for misunderstanding that I would like to,
Ms. Richmond, I mean,
okay,
you know, you're
I
not-
get it,
You're not.
Judge
fooling-
Gothier, I know what happened,
You're
but
not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
contempt hearing
codes
on
and
both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m. I find that Ms. Richmond is unequivocally exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Richmond's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of excuse me, that's a question of law that you can research before that day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself because an attorney, you know, has access to and better training and researching the case law, interpreting what that is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been
Tell
down
me
that
what
path
those arguments
before and it never turns out the way they first present themselves to you, that they're going to fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yep, Ms. Richmond, if you want to represent yourself, it's a little bit more work. You're going to have to
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with. Or that anybody has any proof of what they said here. So that's what
All right, well, that's what we'll.
All right,
sort out those
thank
legal
you.
Arguments and the prosecutor will present witnesses at that hearing and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I
Right.
would review. It'd be the district court office
Okay.
that I would review and I would issue the subpoena. If it's.
So one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association. Am I correct?
That is correct.
Now,
Man, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of other
get it,
charges to
but
set.
I
Right.
appreciate that this is very big in scope and Michigan statutes and codes, as he says, he's compelled to follow or must obey the dictates. Okay, I'm very well versed in enough constitutional things, so I have to know what the perception is there. So, thank you, I appreciate
And Ms.
any
Richmond,
clarification.
I do have to follow what the, any decisions of the Michigan Supreme Court are binding law on the lower courts. There are constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
Oh, she's not gonna come testify, I'm sure. She's downstate. She might write something.
Well, that's up to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case. But I'm giving you the extra time you've asked for.
So this is a major judicial review. okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights. I recognize all those constitutional rights. Of
And
course.
most of what I talk about actually falls under common law because it's common that anyone could understand it.
All right.
That's
so
why it's called
you
common.
set the hearing date.
Okay.
We'll bring you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of the her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had that date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have concern about her appearance at the next trial, the next date.
All right, Ms. Bridgman, anything you want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether
I showed up at 9 a.m., Your Honor, and anybody could call me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court? That's the overarching question here, I think. And I think a lot of people
well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
Oh, I know how it happens.
Your Honor,
I also
pardon
know
me.
we don't have a
Your
lot
Honor,
of
Your Honor.
judicial review.
So
Your Honor,
as the
pardon
bond
me.
question, any input, Mr. Villanueva?
Yes, I guess I know you just released me as the attorney of record, but I guess in support of the bond on her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history.
This courtroom case centers on Noah Bay, who appeared before the court for sentencing after a violent shooting that prosecutors described as a carefully planned attempted murder. The case stemmed from a bitter custody dispute involving his 13-year-old daughter, who had been raised almost her entire life by her maternal grandmother. Just days before a custody trial was scheduled to begin, the grandmother became the target of a shocking ambush that forever changed her life. During the sentencing hearing, the victim emotionally addressed the court, explaining that she had cared for Noah's daughter since she was only 9 months old and had primary custody for years. She testified that Noah's daughter did not want to live with him and that she believed he intended to kill her. The shooting left her with a painful gunshot wound to her leg, destroyed her vehicle, and caused lasting physical and emotional trauma. She told the judge that the attack robbed her and her family of their sense of safety and asked the court to impose a sentence that reflected the seriousness of the crime and protected the public. Prosecutors argued that the attack was not an impulsive act, but the result of extensive planning. According to the evidence, Noah called off work, dressed in black clothing, secretly loaded an assault-style rifle into his vehicle, and drove more than 50 miles to the location where he knew the victim would be traveling. Using location information, he allegedly tracked her routine and waited hidden in a tree line for more than 20 minutes before opening fire. Multiple bullets struck the victim's vehicle, and prosecutors argued that the shots were aimed at the driver's seat, demonstrating an intention to kill rather than simply frighten her. The gunfire also struck another passing vehicle, seriously injuring an innocent woman who still carries a bullet in her body. A nearby home was hit as well, placing even more innocent lives at risk. After the shooting, prosecutors said Noah calmly returned home, hid the weapon, changed his clothes, bought cigarettes, and repeatedly lied to investigators by claiming he had been home all day and owned only a shotgun. Although Noah entered a no-contest plea, he submitted a letter claiming he had no memory of the shooting and insisted he would never commit such violence if he were in his right state of mind. Prosecutors rejected this explanation, arguing that every step of the crime, from the planning to the attempted cover-up, proved that he acted deliberately. They described his claim of memory loss as unbelievable and asked the judge to impose a sentence between 30 and 40 years in prison, emphasizing the danger he posed to the community. The defense argued that Noah had accepted responsibility by entering a no-contest plea and asked the court to consider mitigating factors when determining his sentence. Defense counsel also noted that Noah intended to appeal certain pretrial rulings and requested that the court recognize his cooperation during the proceedings. Before announcing the sentence, the judge delivered a powerful statement, saying that in nearly 10 years on the bench, he had never encountered such a calculated and methodically planned ambush carried out over a potential custody ruling. The judge expressed shock at Noah's actions, criticized his lack of remorse and accountability, and stated that protecting the community was the court's highest priority. The court ultimately imposed multiple consecutive prison sentences, resulting in a decades-long prison term. The defense immediately noted its intention to appeal, but the judge concluded that the seriousness of the crime and the extraordinary level of planning justified the lengthy punishment. The case serves as a powerful reminder of how personal disputes can escalate into devastating acts of violence, leaving lasting consequences for victims, families, and the entire community.